I've heard that in some cases, changing the length and thread of a screw and moving its position in the construction of a patented machine may make it immune to patent infringement. So if material alterations constitute an infringement, how is it that changing a screw, which seems so much less of a change to the original design, not be considered an infringement? Is there simple guidance to follow if an inventor's intellectual property has been violated or not? Or did I just hear a bunch of nonsense? I'm not asking for legal advice, but just in general. Yeah, good. So I think the question is, to what degree can I build something, make something, use something, and avoid infringement? And I'm not sure if I followed the screw example, but what I can say is that when you're making a product and you're worried about whether you're infringing on the patent claims, you have to go read each claim. And the claims of a patent are at the very end of it. They kind of make you read through all the description, all the drawings. That's not what the inventor, what the applicant, the owner of the patent actually owns. They own the claims, the written numbered set of claims at the very bottom of the patent. And so start with the independent claims, usually independent claim 1, and you've got to break it down into the little elements. And we'll look at an example from the Shark Tank pitch later today where it'll have structural elements, right? It'll say, a machine with a bottom case, having a plurality of penetrations for securement attachment, wherein the attachment has a positional ornamentation for rotation around its axis, right? And they'll have maybe 4 or 5 other elements where it'll say, and then the dependent claim might be the said attachment mechanisms can include or consist of screws. Okay, and so that's one of the potential embodiments is to attach this machine to the top with screws. I think the fact that you're using any type of attachment means screws or not, or adhesive or not, probably likely going to be infringing. The way to avoid infringement would be to not have in one of those elements in the independent claim. And I know I'm talking a lot here, but that concept would be if you're able to come up with that same motor without having any attachment means, now you're not infringing, right? Or construct it so that it doesn't rotate around its axis at all. It's fixed. That's not infringing. These are relatively technical, and I think before you put a ton of money or effort into buying or manufacturing or developing a product, you want to get with an attorney, patent attorney, and work on what this is, the FTO, freedom to operate, and say, hey, I'm going to market with this product. We're not necessarily looking to get a patent ourselves, but I'm worried about this patent. Am I infringing it? And get an opinion from an attorney that says, you know what, no, the elements here, you're not on the merits infringing, and if you were sued by this company, we stand behind the fact that you are not infringing. And so it's something you'll want to have, especially if you want to go after higher investors. They'll be assured by the fact that you've got an attorney review it, before you've gone to market, taking that big risk of litigation.